Welcome, everyone. I'm so glad that we're back now after we've had the summer off. Let's go over some housekeeping matters before we get started with our presentation. First of all, you have to stay on pursuant to Utah Supreme Court CLE rules for the hour in order to get credit. We will submit your names to the bar, so don't worry about that. Secondly, if for some reason you drop the call or the webinar, whatever you're looking at, and you have to sign in under a different ID, email me and let me know, lori.nelson@law.utah.edu, so I can make sure you get credit. I don't want anyone to watch part of it, drop it, and sign back in under a different name and then not get the credit for it. Okay, last, before we start, if we're going to reserve questions for the end, please use the Q&A feature, not the chat feature. Use the Q&A, put your question in, and the upvote button works. So if you see a question that you thought about asking, but somebody else has asked it, click the up arrow, and that will raise that question up in the queue. Now, it's my privilege to be able to introduce your panel to you to talk about Title IX and the significant difference Title IX has made in the educational environment. First, we're honored to have Nancy Key Cantalupo, who's Associate Professor of Law at Wayne University. Nancy is a recognized scholar, a nationally recognized scholar, and expert on Title IX, sexual harassment, and gender-based violence in education. We also have with us Sherrie Hayashi, who is the University of Utah's Title IX ADA and Section 504 coordinator, and her classmate. They graduated the year before me, so they're cooler. Her classmate, Laura Gray, who worked for a long time in Utah before she went to England and got her certificate in international human rights law, and then came back and resumed her practice here in Utah. So I'm going to start this off, and Nancy, I'll turn it over to you. Thank you very much.
Thanks so much, Lori. I'm going to share my screen just to share a single slide to get us started. So this is just to show you how Title IX is this amazingly short statute, right? It's 37 words, which is the title of a book that has just been published about Title IX's history, which, just sort of emphasizes how short it is. But if you look at the language, you can also see how broad it is. And that breadth really has made all the difference in the world in terms of why Title IX has become the force that it is. And I'm going to stop sharing my screen. I assume that 37 words, everyone has had a chance to read the statute. If not, I'm sure you can find it online. But, despite the breadth of Title IX, in the popular imagination, Title IX has usually meant a specific issue, right? And that issue has shifted based on the time and the sort of generation of people who one is talking to. 70s, 80s, 90s, it was really, if you asked the, person on the street, I think they would have told you that it was about women in sports, right? Women and girls in sports, equal athletic opportunities in school for women and girls in school. But then over the 2000s, we saw a bit of a shift happening where Title IX started to get used to address sexual harassment and gender-based violence more and more. And by the mid 2010s, that was arguably what many people, even people on the street, again, would have thought that Title IX was about. And now with the culture wars over transgender students, I think some may already think or come to think that Title IX is really about transgender student rights. So, it very much depends on one's perspective and sort of what the hot topic of the day is. But if you look at that statutory language, you realize that Title IX is about all of these things and much, much more. It's applicable to all of these problems because they are all inequities and forms of gender discrimination that exist in US education. They exist many other places as well, but Title IX applies to education. So a conversation or organizing strategy that's based on Title IX is going to be concerned with these problems and these inequalities in education as they manifest in education. And, just a beginning list of the other inequalities in education that Title IX has been used and will continue to be used and, potentially could be used even more to address and prevent and remedy. There's intersectional discrimination based on, for example, race and gender. Sorry, I'm in an office that keeps turning off the lights. So if I wiggle around, that's the reason. So intersectional discrimination based on race and gender together, or gender and disability together, or all three together. These have increasingly become part of what people use Title IX to address, and use it in conjunction with other civil rights statutes that apply to US education. There's also discrimination in hiring, promotion, equal pay, as well as retaliation against employees who assert their own or others' Title IX rights. And so, so there's a whole employment aspect of this that Title IX applies to. There are other statutes, most particularly Title VII, that also apply, but you can use both. And so Title IX is relevant in that area. Title IX has also increasingly been used and discussed when it comes to pregnant or parenting students and employees and their rights, as well as the issues of discrimination against menstruating persons and, again, anything having to do with reproductive rights and reproductive justice. And really the reason why some of these inequalities have gotten more attention than others is simply because a larger number of activists and advocates and attorneys have invoked or applied Title IX to dismantle particular inequalities. There, as you could see from that list, there are many, many that plague and are persistent in US education. But there's been whole movements that have really organized around those particular, the hot topics that I mentioned at the beginning. So the history of Title IX is as much about how students, especially, have organized around Title IX and used Title IX to protest and seek to eliminate the particular inequalities that they are concerned about. And because I've spent over 27 years working to combat sexual harassment and gender-based violence in education, the wave of Title IX organizing that I know best, and that I've been most a part of, is the wave that started to get widespread attention, round about 2013. So, I can talk more about the specifics of that later on in the program, but I want to give my co-panelists a chance to say more about their specific areas and to deliver their comments. But I look forward to talking more as the program goes on about all of these areas, but particularly the part that I have the most expertise in.
Thank you, Nancy. I really appreciate all that Nancy has said. I think that as we were talking a little bit before this program, we talked a little bit about sort of the intersection of the advocacy that she spoke about and regulations. And so my focus is going to be on the regulatory framework used by the Department of Education Office of Civil Rights for the enforcement of Title IX. And we all know that typically government they're not the leaders in all of this, right? That oftentimes the advocacy that I think Nancy spoke about really is there becomes this point where especially enforcement agencies, compliance agencies, need to step in and provide some direction, especially for institutions. And so it really is sort of reactive to sort of the things that are going on in larger society. But I'm planning on talking about sort of that regulatory framework. So let's see. We looked a little bit at the language of Title IX, and I won't really repeat that or recover that. But let me just talk about, in terms of Title IX, we often think of K through 12 and higher education, but Title IX applies to all aspects of educational programs and activities operated by recipients of federal financial assistance. In addition to educational institutions, Title IX also applies to any education or training program operated by a recipient of federal financial assistance. So, for example, a prison that has an education or training program is also subject to Title IX. As Nancy mentions, Title IX of the Education Amendments Act was passed in 1972. And again, I won't repeat the language here, it's up here on this slide. And the history, as we know, initially made groundbreaking strides in terms of athletics, but really Title IX stands for so much more: admission, testing, access to programs, opening opportunities in STEM fields, and in its 50 years, it has truly changed access to education in so many different ways. But fundamentally, Title IX is a civil rights law. So 50 years later, much of the discussion about Title IX focuses on sexual harassment or sexual misconduct. But again, fundamentally, Title IX is a civil rights law. So let's talk a little bit about the history that brought us to today's world of Title IX. Sorry, I'm having slide issues. So in the 1980s, federal courts held that sexual harassment constitutes a form of sex discrimination under Title VII of the Civil Rights Act. But it wasn't until the 1990s that courts began to apply similar rules to schools under Title IX. OCR then issued a series of guidance documents built on these judicial precedents. In 1998 and 1999, the Supreme Court handed down two key Title IX decisions that set the stage for the current landscape: Gebser versus Lago Vista Independent School District and Davis versus Monroe County Board of Education. The cases lay out the basis for which an institution can be held liable for sexual harassment when, one, they had actual notice of the misconduct, and two, responded with deliberate indifference. The court also defined that the misconduct must be so severe, persistent, and objectively offensive that it effectively bars the victim's access to educational opportunity. The court's decision was different than Title VII liability, which uses a constructive notice standard and is based upon whether the behavior is sufficiently severe or pervasive. So again, the language is sufficiently severe or pervasive, such that a reasonable person would find that the conduct to be objectively hostile or abusive to create a hostile or working environment. OCR also took the position that the court's interpretation only applied to lawsuits against institutions, not the conditions that attach to federal funding. So OCR's guidance to educational institutions was through a series of documents known as the Dear Colleague letters. Key among these, in 2011, the Obama administration issued a Dear Colleague letter on sexual violence, providing the framework for schools to end harassment, eliminate a hostile environment, and if it has been created, prevent harassment from occurring again. In 2014, they followed up with guidance, which was titled Questions and Answers on Sexual Violence. Then in September 2017, the Obama-era Dear Colleague letters issued in 2011 and 2014 were rescinded by then-Secretary Betsy DeVos, and the department announced proposed regulations would be issued. At that time, a new interim Q&A was issued, bridging that gap until new regulations were in place. A little more than a year later, on November 29, 2018, the department issued a notice of proposed rulemaking pursuant to a formal notice and comment period. The administration took nearly a year and a half to review the more than 124,000 comments that were received. The new regulations were issued on May 6, 2020, giving institutions 100 days to implement the new regulations and come into compliance, despite the fact that there were significant changes required of institutions. This was actually also the first Code of Federal Regulations on a major Title IX issue since 1975, and the only regulation dedicated to sexual harassment. So where are we today? On June 23, 2022, the 50th anniversary of Title IX, the Department of Education issued a new notice of proposed rulemaking. More than 235,816 comments were submitted during the 60-day comment period, which closed on Monday earlier this week. And to understand these recent proposed changes and what they mean, we should take a closer look at the 2020 regulations. So the 2020 regulations, which are the current regulations under which institutions are currently operating, you'll notice that the regulations rely heavily on the Supreme Court's decision in Davis and Gebser that I had mentioned before. The regulations are very, very detailed in terms of procedure, but there are some key provisions to take note of. So the first is that they define the obligation that institutions not act with deliberate indifference. And then they spell out what needs to happen by institutions in order to not act with deliberate indifference. So institutions must provide supportive measures and a grievance process. The 2020 regulations also define sexual harassment, and you'll see that this language comes from Davis. So it defines sexual harassment as severe, persistent, and objectively offensive that it effectively bars the victim's access to educational opportunity. The current regulations also change an institution's obligation from constructive notice to actual notice. Except for K through 12, a K through 12 student can report to any employee, and that constitutes actual notice to the institution. Higher education is also required to have a live hearing in all sexual harassment cases that are covered by Title IX, and respondents cannot be held responsible until a finding of responsibility has been made. So I'm sorry, I was on the 2020 slide. I'm sorry, I'm having just a little trouble navigating. So let me just talk about the 2020 regulations. I'm still having problems with this. Sorry, my mouse seems to be very sensitive. So here are the 2020 regulations. So we visibly see that pendulum swing in 2020 with the recently issued NPRM, the Notice of Proposed Regulations. The proposed regulations define the sexual harassment as unwelcome conduct that is sufficiently severe or pervasive, which is moving away from the current standard of severe, pervasive, and objectively offensive. So that's a major shift in the standard under which institutions would evaluate sexual misconduct or sexual harassment cases. The mandate for a live hearing is now eliminated, giving colleges more flexibility. They certainly can hold a live hearing if they so choose, but it is now it will not be required under the new proposed regulations if they become in effect. Schools are also required to give more notice about Title IX protections and access for reporting. It also confirms the protections from retaliation. Nancy had also mentioned that there's greater attention to pregnant students and those responsibilities. So again, the Department of Education has prior guidance on this issue, but it is significant that they have chosen to incorporate into the proposed regulations addressing pregnant students. Specifically requiring clean lactation spaces that are not bathrooms and other reasonable modifications to policies, procedures for pregnant or parenting students. The new proposed regulations also clarify that gender expression and gender identity are forms of sex discrimination, and then and therefore covered by Title IX. So what does the future hold, at least for the near future, and what is needed? The regulations do seem to be a better method than guidance documents in establishing that regulatory framework, and they seem to be here to stay. Within the Notice of Proposed Regulations, the Title IX landscape of sexual harassment will be changing again. It is really to be determined how long the Department of Education will take to review 236,000 comments. It's likely that it will take some time. I would not be surprised to see it take perhaps a year for them to review all of those and to make the revisions that are necessary. And then I think one thing that people will want to look for is to see what OCR does with those regulations regarding gender identity and gender expression. What I understand is that a significant amount of comments involve responses involving gender identity and gender expression, the proposed regulations. So just as a sort of closing comment to my section, one of the things that I did want to impart to people is that what we need is as institutions, and I'm going to talk about this from my perspective as a Title IX coordinator, is that we really need stability. So one of the things that's so important, regardless of the procedures, is that there needs to be a very clear regulatory framework for institutions. Changes can be costly, but to make all of those changes, but even more importantly than the cost is the importance of changing regulations and how it impacts students. It can be very confusing for students to hear that the regulations are one way for certain cases and a different way for other types of cases, to not know what to expect, both in terms of what expectations are for behavior, but as well as for addressing and reporting issues of sexual harassment and sexual misconduct. And it's really important that we want students to be focused on their academic endeavors. They should not be trying to navigate complex processes for addressing sexual harassment. And it is important, especially as public institutions, but all institutions, that it's important that elements of due process and fairness also are part of the process, but it's also very important to make sure that processes are accessible to students. And so just my parting words are to stay tuned. Expect that it will take a while for OCR to review those 200,000 plus comments. And I guess we will see where that goes. So stay tuned.
Okay. Thank you, Sherrie and Nancy. It's really good to hear from the experts on this. So some of you may know I've done a lot of civil rights advocacy here in Utah for the LGBTQ community. And I also worked briefly with the United Nations, helping them develop some of their policy around protecting LGBT people in the refugee area. But I'm really excited to see that Title IX see it as this amazing tool that's evolved over time to be so powerful. But what I wanted to do today, because we're celebrating the 50th anniversary of this statute, and because I'm a lady of a certain age who really lived through seeing this first implemented in the 70s, and to see what the effect has been over time, I wanted to just be more anecdotal in my comments. And I have just done a little research and talked to a few people about how this has affected them and myself. And I wanted to share that with you. And then we can go to questions. So in the 70s, 60s and 70s, or up to the 70s, if you were a girl, and I was an active girl, you could play with the boys and do sports in your neighborhood. But then when you went to school, the boys got to go on all of their teams, and us girls got to go to gym class. There were no, when I first started school, there were no teams for girls. And I don't know if you guys remember those horrible one-piece polyester jumpsuits that you had to wear in gym class, but I sure do, and it was pretty horrible. So anyways, that was kind of my first exposure, and all of us girls' first exposure in the 70s to the inequities in sports. And so what I want to talk to a little bit is about the old gender-based sports stuff that I was involved in growing up. One thing, and so when in terms of sports at that point, the boys got to go fulfill their dreams in high school and college in terms of sports, and also have all of the educational opportunities that came with that. And for girls, it just really wasn't an option. And so Title IX really was enacted in 72, but you didn't really start seeing any of the changes until probably the mid-70s. And so when I was in high school, I finally got to play on the girls' tennis team. And that was sort of my first exposure to a team sport and being able to get out of my horrible jumpsuit and into something more appropriate. One thing that I've learned in talking to a few of the coaches who have been around for a long time in terms of the application of Title IX is that the NCAA had to be forced to recognize Title IX. They really disregarded women in terms of wanting to open the door to sports activities. They filed a lawsuit. They lost that. They went to the Department of Education and lost a battle there. And so women and girls became able to engage in sports. But one thing I wanted to mention is that the NCAA still has problems to this day in recognizing female athletes. And one of the big examples of that was, I think, in 2020, when it became apparent that in basketball during the March Madness, the perks and the opportunities that the men had were completely different to what the women had. And the only reason the NCAA really made any changes was because of outcry and because of media attention. And so I still think in some of these areas, we do have a long way to go in terms of making sure women have the same opportunities that men have had. I wanted to talk a little bit about the difference in sports in terms of teams. I played club soccer at the University of Utah back in the day when I was an undergrad and a little bit during law school because there was no collegiate team and I wouldn't have been good enough if there was. But on our club team, we had no money, no coach. Maybe the university paid for our t-shirts. Now we have a very, very successful varsity women's soccer team that has 35 team members, probably most of whom are on full ride scholarships. And so I think we can see some of these huge changes over time. One example I wanted to share with you was the change in women's gymnastics. The women's gymnastics team was first established in 1975 with a total annual budget of $4,500. The first coach was a graduate assistant coach, Greg Morrison. He made $1,400 a year, and they had 4 in-state tuition waivers to offer their students. He also had to borrow money to buy equipment, and then had to have a camp in order to raise money and pay off the debt on that equipment. And perform in some small gym somewhere on campus. Fast forward to 2022, the budget of Utah Gymnastics is roughly $1 million, 3 full-time coaches, a head coach and 2 assistants, paid athletic trainer, director of operations, and a social media coordinator, and 13 full-ride scholarships, which include room and board. That gymnastics team that started on borrowed equipment in a small gym now performs in the Huntsman Center, regularly pulls in 14,000 people for each of their meets. So we can see, although the NCAA has had to be dragged along, we can see just amazing changes in terms of the opportunity for women in sports. And lastly, I just wanted to say, I interviewed, I was at Whole Foods the other day, and the entire Illinois State women's soccer team was walking out. And so I accosted them and started asking them questions about being on that team. And so they were all very aware. The ones who stopped to talk to me thought I was kind of this crazy person, but they stopped to talk to me, and they were very aware of Title IX and its status and how it had affected them. They considered themselves, and they were elite athletes who worked very hard at their job, along with going to school, and they were pretty appreciative of that. They were very happy to have a female coaching staff for their women's soccer program, and they proudly mentioned to me that at Illinois State, the women's sports were more successful than the men's teams. And they had received training on Title IX and sexual assault on campus. Nancy, that will make you and Sherrie happy. And we're very aware of its application. And their school had recently installed a statue on campus dedicated to Title IX in this 50th anniversary year. And I asked them, what it meant to them to be involved in sports on a collegiate level. And they said that soccer had made them tougher, more resilient, and confident on and off the field. So while Title IX has been applied really broadly over years, and I find that fascinating how life has been breathed into it in so many different ways. I also just wanted to share this of where it all started and what a huge effect it has had on so many people, so many women in this country. And so that's what I wanted to add, a little kind of personal anecdotal info. And so I think we can open it up to questions at this point, unless anybody else wants to add anything that we've missed.
I'll just say a couple of things about in response to both of your to your presentations. The story of athletics and the way in which athletics has really made all kinds of other things possible for women in education, along the lines, Laura, that you were just saying right at the end. So for anyone who is here, I highly recommend reading that book that I put up at the beginning, 37 Words, because it really shows you a couple of really interesting stories about Title IX. One is that Title IX was kind of snuck into US law. And part of the reason why athletics got so much attention at the beginning was because everyone's attitude about Title IX at the beginning was, well, yeah, go ahead, pass your little law dealing with gender discrimination in education, because we don't have gender discrimination in education. And so, go ahead, pass it. It's not going to do anything because we don't have this problem in education. And it was like practically minutes or hours after it passed that the coaches in particularly colleges and universities said, wait. There is all kinds of stuff here that we are now going to have to do, that athletics programs are going to have to do, that we didn't have to do before. And that's part of the reason why athletics was the first sort of site of Title IX changes, because it was so stark. The inequities were so stark, as you were talking about, Laura, and it was so obvious. And so that was the place where people were like, oh my God, there is inequality in education, and now there's this law, and we have to do something about it. And with regard to Sherrie's comments, I will just add, the preamble to the new regulations was something like 600 plus pages long. So there is endless stuff to talk about related to those. The one thing that I will just say is that in in many ways, from the perspective of someone who has spent, decades now studying Title IX and, is pretty up on all of the law and interpretations on Title IX. These regulations really put Title IX back to where it was prior to the DeVos regulations. There are all kinds of ways in which we can see how the DeVos regulations were actually designed to undercut and undermine Title IX and to, essentially weaponize the Office for Civil Rights against its own statute, against one of its own statutes, and force it to engage in enforcement that was going to be against the purpose of Title IX. And, we can talk, there's, again, endless things that we can say about the reasons for that. But I think it's important to remember that what the Biden-Harris administration is doing in these new regulations is trying to restore Title IX back to its original sort of civil rights purpose and civil rights, format. And so, those were the two things that I just wanted to add based on your comments, which I thought were just fabulous.
Thank you. So the audience won't know this, but we were talking earlier about the progression of Title IX and when things have happened and why. So a couple of questions come from that. The statute specific, well, we all know that statutes mean what the courts say they mean and what the regulations say they mean. But the language of the statute says it applies in federally funded education. So my question is, can and how does Title IX apply to private schools that have no federal funds? And then also, how does it work with grammar schools, not colleges?
So I'm happy to take the first shot at this. So federal funds come from loans. For private institutions, the loans that students get to pay for their tuition, those loans are largely federally funded. And so any school that is getting paid by students who are relying on federal loans that counts as receiving federal funds. And that is the mechanism that pulls in almost all of higher education, post-secondary education, into the ambit of Title IX, as well as the other civil rights statutes. They all follow the same kind of format. They're passed under the spending clause of the Constitution, and they apply really broadly because of the loan structure. There are other ways in which major research institutions like the University of Utah or my institution, Wayne State, major research institutions also get all kinds of funding in terms of research dollars. But that's just, a sort of, that's a different way in which federal funds come in. Some schools that don't have a big research mission would not be pulled into Title IX based on that. But so the loans are really the thing that makes almost all of US education federally funded.
What about lower education?
So K through 12, of course, is they receive, so most of K through 12 public education is funded by state budgets, but they get federal dollars in smaller amounts, or the states may get federal dollars that are then passed through to the schools. And so the public education system is absolutely, and that's the vast majority of K through 12. So they're included because of that federal funding. They're probably the largest group of schools that are not subject to civil rights laws like Title IX, are independent K through 12 private schools that often do not accept loans. They require their students to pay out of pocket to go there. And so because there's no loan structure, they're not getting federal funds as a result. And they're not getting federal funds because they're also private, and not getting funding through the government. So that's probably the largest group of schools that don't have to comply with Title IX.
Laura and Sherrie, do you have anything to add? Okay. A question from an attendee. Given all of the panelists' experience with Title IX over the years, what do you see as the primary issues our daughters should work toward next? What are the important issues on the horizon and how should they be addressed? Any thoughts?
I'll just step in here, but I think a lot of the structure is there. It will be interesting to see. I think that the especially with the Supreme Court cases, I think that there's pretty solid foundation for gender identity and sexual orientation to be embraced in that definition of sex. But I think that it is an area on the horizon to keep to continue to monitor. But I do think that that's where there will be a lot of changes, especially sort of that guidance that from the federal government that guides institutions. But I will just say, I think that the more powerful piece is really, these laws and the structure is in place, but it really takes people to exercise their rights, to step up and to exercise those rights and to push institutions, to push programs to be responsive when something is an issue. And that goes true too for sexual misconduct. There's a lot of training on bystander, active bystanders. People, if there's something that there's someone seeing or experiencing, it's important to stand up for that. So I think that that's maybe one thing that I would advocate for, like my own daughter too, just to make sure that she understands that she has an obligation to speak up and speak up for others as well.
I think I would just add to that, to my mind, Title IX, and we were talking about this a little bit before the session started, to my mind, Title IX it's about gender inequality, right? And boys and men also experience gender inequalities. It's a lot more complicated for them. And certainly in the sexual harassment context, the abuse that men and boys often suffer is usually at the hands of other men and boys. So it gets complicated, right? Because it's more complicated than how we normally think of gender inequality. But, you know, to my mind, the future, and, you know, gender nonconforming folks and the transgender rights movement, everything is, gender is getting more and more complicated. And so I really think that this is something for all students to be paying attention to and thinking about, and, you know, thinking about not only how they can use a statute like Title IX, but how they can use the other civil rights statutes that are there to protect them and protect their rights. And, you know, there's so much that smart and active students and people can do with those statutes. And, you know, I hope that they all, you know, use them to the greatest extent possible.
So, do nonprofit tax exemptions count as receipt of federal funds such that they would be subject to subject a private school that does not otherwise benefit from federal aid, subject that type of school to Title IX?
So I don't know the answer to that particular question. You know, there are very few schools at the higher education level that don't accept loans, or, you know, aren't allowing their students to pay for tuition using loans, and that pulls them in. And so therefore it's, the other questions end up being irrelevant. So, you know, the vast majority of private institutions in US higher education are in fact nonprofit organizations. But that question wouldn't come up because they're all accepting federal funds in the form of loans that their students are using to pay for tuition.
The newest threat in K through 12 schools is the attack on race and gender identity or expression. Title IX, Title VII, and free speech. Young teachers of TikTok who discuss equity or gender ID or racial representation, for example, are targeted by conservative social media and doxxed, outed. And then the conservatives are directed to call a school and district that also have ties to the conservative media. The result is to have the young teachers investigated and disciplined discrimination. So would Title IX then be a tool for those teachers?
In my opinion, there would be an argument for a retaliation claim under Title IX. So if you are doing something as an employee, as a teacher, that asserts the Title IX rights of, and the civil rights of a student or another staff person, and then you are penalized for that, then there's potentially a there's potentially a retaliation claim under Title IX.
Okay. Sherrie, this is a question for you. Do the proposed regs take away the hearsay restriction from the 2020 regs?
Let's see, I'm trying to actually remember how that's dealt with. So generally it does. So for those who are following, so again, it's a balance based upon the evidence that's before the decision maker. It's interesting because, you know, the 2020 regulations really are in the context of that live hearing perspective. And so now that live hearings are not required, I'm trying to remember, there's actually some language that we were looking at that we thought could be clarified, but it really is about, making sure that the decision maker is looking at all of the weight of the evidence. And hearsay can be important, but in any investigation, it's always a balancing act, but it's not specifically excluded as it was originally in the original 2020 regulations. There were some changes. It's kind of a long history to explain, but there was a court case involving some of those provisions, and the Department of Education made a revision to some of those provisions. So it's kind of a long story to sort of explain here, but it really should be a balancing act that, all of the evidence should be taken into consideration, determine what the weight of the evidence is and how evidence corroborates certain other evidence. So it's a balancing test.
Thanks. So just an observation, Laura's comments about the used women's gymnastics program and its evolution from next to nothing to its present powerhouse status is pretty amazing, which also prompts a question about why the U has never pursued a men's gymnastics program. I wouldn't have any idea. I assume that if there was an interest, it would happen, right? Okay. How do you figure Title IX will factor into the current transgender interscholastic sports controversies? Any suggestions, thoughts?
I think, the new regulations do try to, in some ways they really tried to avoid that discussion part about athletics. At least that's how I sort of read the regulations. I think it's going to be something that is going to be, something that's debated. And I think that there's going to probably be some decision making that needs to happen by courts to sort of balance out the legislation that's being enacted by states and, the conflict really with the premise of Title IX and inclusion of gender identity and gender expression. So I just think it's something that will likely end up having to be settled by the courts, but that's my personal opinion. I kind of want to circle back a little bit to the earlier question about athletics, and so it's this complicated piece about a men's gymnastics team, a women's gymnastics team. The Department of Education has really set out some standards for evaluating, and what they're not necessarily looking for pure equality, so men's gymnastics team and a women's gymnastics team, but it is based upon sort of demand and interest in a particular sport. But it's about resources and making sure that that there's that balance between athletics, between gender specific athletics. I think that this is also another area. I think it's just going to get more complicated. I think Nancy mentioned this as well. Like, our understanding of sex and gender is evolving. Like, I was looking at some of the older regulations just in relation to a different question that came up. And, they were very based on sort of a very binary definition of sex. And so I think as a society, we're evolving in our understanding of the complexities of sex and gender. So it'll be interesting to see how the law and how, Title IX evolve along with that.
And one of our recent graduates, hey, Chris, says, one major reason for no men's gymnastics team is the number of players on the football team. Many schools that have a football team have more women's sports than men's sports to balance out the number of athletes of each gender across the sports. So thank you for that, Chris. Can Title IX be used to counteract some of the Don't Say Gay and other laws which are being enacted in some state legislatures?
I think that is a probably looming legal fight. There are a number that are looming, I think, but that is one of them. And because I don't think that there is very clear case law about the preemption question. And so, you know, and in addition to just preemption, there's all kinds of layers of preemption, right? Because, you know, does Title IX preempt? Does the statutory language preempt? Does the, do the regulations preempt? Those types of things are probably going to end up being litigated in court before we have a real definitive answer.
From a Title IX perspective, is it problematic? Oh, and Nancy, you won't know this. Our then gymnastics coach married one of his former athletes while he was still coaching gymnastics. Would that be a problem under Title IX?
I don't think it's a problem unless the relationship, well, it's going to depend on what the institution's rules are, right? Partially, but remember that the structure of liability under Title IX and other civil rights statutes like Title VII is that when so this is for hostile environment sexual harassment, right? So when let's say a student comes forward and says, I have been sexually harassed. It's like unbelievable how this happens every time I'm talking. What happens is that a student comes forward, right? And the institution is required to do something, right? And to prevent that individual, you know, that conduct from sidelining the victims' educational opportunities, right? And access and educational environment. And so the university has to do something, or the school has to do something. And it depends on what they do. Their liability is sort of what the court is going to be looking at is what did the school do, not what the underlying conduct was.
I see.
And so that's going to be dependent on what is the school's policy, how did they enforce the policy, was it consistent, and in the end, it requires a complaint, right? So presumably, the student that the coach married is consented, right? That student doesn't have a problem with that relationship. Therefore, that student would not complain. Therefore, there would never be even an issue of whether or not there's a Title IX violation.
Well, and they went on to jointly coach a fairly successful gymnastics team. So does Title IX apply to allegations of gender-based discrimination in employment decisions? Where there are no students or traditional educational activities? And we were talking about this, that it applies to more than sports, and it applies to more than, you know, the binary woman. It applies across genders, and it applies across structure as well.
Yeah, that's correct. So Title IX applies to the institution. The institution shall not, you know, is required to ensure that there's no discrimination. And so it really, in any of its programs or activities, so that applies to students, staff, faculty, across the board.
And there's a little bit of Title IX history, again, 37 words for people who want, people who want this kind of backstory. But Title IX was actually sort of spearheaded by a woman named Bernice Sandler, who originally pressed it because there was an exemption under Title VII for education. So Title VII did not apply to gender discrimination. Title VII applied to workplaces all over the place, except for education, right? Because remember, there is no discrimination, gender discrimination in education. So Bernice Sandler took it upon herself to, she started out with other legal mechanisms, but her main target was gender discrimination in employment in educational institutions. And it just, they eventually got rid of that exemption in Title VII. But it still applies. It's still a part of Title IX and a part of Title IX's history.
Which is what brings us back to the beginning, and that is Title IX is much deeper and much broader than it seems at first glance. So reading articles that you, Nancy, have written and the book, 37 Words, I think would give everyone a better perspective of what the benefits of Title IX and what it can do in the educational environment. And then also making sure that the regs say what we need them to say, right? Well, thank you very much to everyone that attended. Thank you so much to the panelists. This was so fascinating. Every time I do one of these CLEs and it's in an area of law that I never practiced, I learn so much, and it's really, really fascinating to get this different perspective of the law and what it can do for us on both a federal and a state level. So thank you to all our panelists, and I hope to see the attendees at a future webinar.